This case, number 2015-692-DM, Muhlenberg v. Muhlenberg, was heard before the Honorable Brian K. Kirkin at the 37th Circuit Court in Michigan on Tuesday, October 8, 2024. Judge Kirkin was not the original judge assigned to this case. He had been brought in through the State Court Administrative Office known as SCAO, specifically to decide the defendant's motion for disqualification of the presiding judge, Judge Tomlinson. The plaintiff, Christopher Muhlenberg, was represented by attorney Emily Risberg. The defendant, Sarah Muhlenberg, appeared pro se. This case had been pending for 9 years, and with 8 of those years being post-judgment. And the matter before Judge Kirkin was Ms. Muhlenberg's motion for reconsideration of the denial of her July 29, 2024 motion to disqualify Judge Tomlinson. In Michigan, judicial disqualification is governed by MCR 2.003, which sets forth the grounds upon which a party may seek to remove a judge from their case. Under MCR 2.003, C.1, disqualification is appropriate when the judge has a personal bias or prejudice concerning a party, when the judge has personal knowledge of disputed evidentiary facts, or when the judge or a member of the judge's family has a financial interest in the matter, or any other interest that could be substantially affected by the outcome. When a motion for disqualification is filed, the challenged judge first decides the motion. If denied, the party may file a motion for reconsideration, which is then referred through SCAO to a different judge, which is how Judge Kirkin came to be hearing this matter.
9 years this case has been going on. We've been post-judgment for 8 of those years. The major decision in this case to award full physical and legal custody to my client, Mr. Muhlenberg, several years ago was actually a stipulated order and determinations by the court. I did not interrupt you, Ms. Muhlenberg.
Yes, don't interrupt her, Ms. Muhlenberg.
And
do not interrupt.
Y'all.
Why do we have an extra person on?
Oh, that's the plaintiff.
Well, we've got 2 plaintiffs.
No, it's Chris. Chris is the plaintiff. Sarah is the defendant. Riceberg is the attorney.
Right. Okay, got it.
Okay.
Cool. Got it.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkin presiding. It is Tuesday, October 8th, 2024 at 1:28 p.m. for case number 2015-692-DM, Christopher Muhlenberg versus Sarah Muhlenberg, attorney Emily Riceberg for the for the plaintiff.
Good afternoon to everyone. Court will note that this matter is before the court on the defendant's motion for reconsideration. The court did grant, obviously, the opportunity to the parties to have oral argument in this matter. And so, Ms. Muhlenberg, it's your motion, so I'll let you go first. I did have one question as I went through the documents that I wanted to clarify before you start. In paragraph 2 of your motion, you state that on or about February 9, 2016, plaintiff father provided defendant mother with QuickBooks backup files on USB of plaintiff father's business Computer Resolution, Inc. And then you have another, and then you said in paragraph 3, on July 14, 2024, defendant mother received the QuickBooks files provided by, or reviewed the QuickBooks files provided by plaintiff father to defendant mother and discovered Judge Tomlinson's name listed as a customer/client, specifically in the 2013, 2014, and 2015 files contained as Exhibit A. Are those dates accurate?
To the best of my recollection and knowledge, Your Honor, yes. May I ask for clarification, what date was that? What date of the motion you were referring to?
Not the day of it. It's your motion for disqualification that I'm referencing.
Right. Is that the January? I believe it's January. There were 2 filed, one on January 29th of 2024 and one on July 29th of 2024.
It's the July 29th, 2024 motion.
Okay.
Which is the motion we're here on today, correct, Your Honor? July 29th. The January one was decided many months ago.
Right.
Well, if I heard for clarification, if I heard you correctly, we were here on the motion for reconsideration. I guess
Yes, it's a motion for reconsideration, but it's stemming from the motion for disqualification dated July 29th, 2024.
okay, and I guess I just need to know which motion for reconsideration we're here on. Perhaps it appears.
No, I'm asking you specifics. I don't care what motion. I'm asking you if in fact the allegations in paragraph 2 and 3 on your motion for disqualification of July 29th, 2024 are accurate on the dates. That's all I'm asking.
Yes, to the best of my knowledge and recollection.
Okay.
Yes.
Then you can proceed with the rest of your motion. Go ahead.
I guess I just need some clarification, Your Honor, because it was my understanding that we were here on miscellaneous matters according to the notice of hearing that I received. And so I didn't realize we were here on this motion because in the last I had knowledge of, it was Attorney Reisberg requested a status conference. I believe she requested that sometime on or around May 8th. And I have not received anything since then about this hearing other than it was on miscellaneous matters.
This hearing never said miscellaneous matters.
No.
Your Honor, may I speak for 1 minute?
Yes, go ahead.
Thank you. What happened, Your Honor, just because I know you're kind of subbing in because of the disqualification issue to hear that. Ms. Mildenberg she's filed several motions for disqualification, all of which have been denied. This is the most recent. She filed it back in July. Judge Tomlinson denied it, and then it came to you through SCAO. We were scheduled on this motion hearing, I believe, on September 23rd. I could be botching that date, but it was at the end of September. It's on Ms. Mildenberg's own motion. She herself asked the day of to adjourn this, and it was very clearly rescheduled to this date. So I don't know why she's suddenly acting like she doesn't know what we're here on. I think that the notice of hearing that the court sent said miscellaneous hearing at the top of the SCAO notice, but she herself requested an adjournment and then worked with Ms. Woodward, who I also worked with, to land on this specific day of October 8th for her motion hearing. So my guess is she's trying to seek another adjournment of this. By acting like she doesn't know what we're here on. We're here today because of her request.
Okay.
And we're here because she adjourned.
May I respond to that, Your Honor?
Yes.
I'm looking at a notice to appear that's dated August 19th, 2024, and it says miscellaneous hearing. I have not received anything from SCAO at all. So if something was filed by SCAO, I did not receive it. And I'm going to ask that if something was filed by SCAO, if there's a proof of service to me, because I don't have, if I heard Attorney Reisberg correctly, she indicated that SCAO assigned this, and I don't have record of that.
You do have record because you're here.
I have record. I received a notice to appear. That's the only thing I received. And it's dated August 19th, 2024. And it says for miscellaneous hearing. Now, the last I had knowledge of, Attorney Reisberg sent an email to the 37th Circuit Court on, I believe, May 8th of this year, requesting a status conference. So
Okay, this is not a status conference. If you look at your notices, the one notice dated August 19, 2024, list says miscellaneous hearing, but a comment, under comments, it says oral arguments hearing will be held via Zoom. The oral arguments on the motion for reconsideration in this matter on disqualification. Under this new notice, the September 18, 2024, it says renotice oral argument hearing at request of defendant. So that is what we're here on today. I don't want to engage in it. I don't know what you've got, what you didn't get from SCAO. If you didn't, you need to contact them and figure it out. This is the motion that you had filed, Ms. Mildenberg, in this particular matter. seeking to disqualify Judge Tomlinson. I was, again, assigned for that purpose. So I'm saying this is your motion for reconsideration. Go ahead and argue it.
Well, I will open with, I do not have a scale assignment. I did not receive a scale assignment regarding that. And I will also say that the notice to appear that I received, the copy I received, did not say anything about the hearing, that it was a hearing on that motion. With that, excuse me one moment, Your Honor.
Ms. Millenberg's basis for seeking disqualification was that she had discovered Judge Tomlinson's name listed as a customer or client in QuickBooks records from her ex-husband's computer repair business, Ascend Computer Technology, in files dating from 2013, 2014, and 2015. She argued that this constituted an undisclosed business relationship between Judge Tomlinson and Mr. Millenberg that created an appearance of bias and a conflict of interest. Judge Tomlinson had already addressed this allegation in his own July 30th, 2024, order denying the disqualification, acknowledging that his wife had at some point around 2013 taken a defective iPad to what appeared to be Mr. Millenberg's repair facility on the advice of a friend. A staff member examined the iPad, determined it could not be repaired, and did not charge her for the brief inspection. No money changed hands and no service was rendered beyond a cursory examination. Judge Kirkin immediately identified the logical problem with Ms. Millenberg's argument, asking her directly whether her position was that a judge or anyone in a judge's family could never engage in ordinary commerce with any business because it would potentially disqualify them from presiding over a case involving that business owner. This question goes to the heart of the disqualification standard. Under Michigan's Code of Judicial Conduct, Canon 2 requires judges to avoid the appearance of impropriety, but this principle has never been interpreted to require judges to catalog every retail transaction or service interaction they or their family members have ever had with every business in their community. Such a standard would be impossible to administer, particularly in smaller counties where the pool of businesses and professionals is limited.
Yes, I would open with saying that this case is replete with facts that indicate the appearance of bias. And to begin with, I'm going to fully incorporate in whole and by reference all of the facts, law, and arguments set forth in my pleadings on record, in my pleadings and on record with the Honorable Court. This most recent disqualification comes because on or about, as you had indicated, on February 9th, 2016, plaintiff father provided me with a QuickBooks backup files on a USB. And when I was reviewing the file of this case, the decisions in this matter were just not adding up. Just something seemed off. There's clearly something off in this case. And so when I was reviewing some of the previous discovery that we had conducted, and that was back when attorney TJ Reed and as well as when attorney Christopher Gergley was representing me at those times. So I pulled out some of that discovery, and it was discovered that Judge Tomlinson's name was listed as a client or customer of Mr. Mildenberg during those times in which you indicated 2013, 14, and 15. And it certainly indicates, to the best of my recollection, Judge Tomlinson's own order. Let's see, he indicated here that Judge Tomlinson did indicate in his order that his wife his order is dated, I'm referencing the order dated July 30th, 2024. And in that order, Judge Tomlinson does acknowledge that after looking into the allegations, that it was discovered that probably about 2013, Judge Tomlinson's wife had an iPad with a defective part and would not allow for the iPad to charge. He indicates that on the advice of a friend, or he stated that on the advice of a friend, she took the iPad to a computer repair facility in Sturgis, Michigan, to see if it could be repaired. She did not recall the name of the facility, which now appears it was most likely Ascent Computer Technology, Mr. Mildenberg, the plaintiff's business. Judge Tomlinson further went on to state or acknowledge that a person working at the facility, after a cursory review of the iPad, stated it could not be repaired and did not charge her for the service. It's my understanding that disqualification is justified in cases where the judge's family is within 3 degrees of that. One moment, Your Honor.
Mildenberg, so what you're saying is that a judge nor anyone in their family could never engage in commerce with any other business because potentially that would disqualify them. Is that what you're saying?
Well, it depends, Your Honor. It's possible. And in this circumstance, I believe it is. Because here we have a case where the judge has acknowledged that his wife, who is within 3 degrees of relationship to him, has sought services from Mr. Mildenberg, did not pay for those services. So a service was rendered. There was no compensation exchange, though, although it appears that Judge Tomlinson acknowledged that that they provided a service but did not charge, so that she did receive something and did not have to in exchange here. But the larger question is, his name appears in that business, and given the facts of this case and that his decisions are not supported by the facts of this case, and the case is replete with violations to mandatory authority. So it's just not adding up here. And in this case, I think it's a case would warrant disqualification. We certainly have a question here of how Judge Tomlinson's name is in Mr. Mildenberg's computer system, in his business computer system as a client or a customer. So I was not informed of that. That business relationship, to my understanding, that is something that is required to be disclosed. To the best of my knowledge, that was not disclosed to my former attorneys, TJ Reed or Christopher Gergley. And so now I'm concerned about that, Your Honor, because it does give the appearance as though there is some sort of business relationship between Mr. Mildenberg and Judge Tomlinson, or there was at one time and it wasn't disclosed.
Well, so what you're saying is if a person goes buys groceries at Myers, they have to disclose when they did that because they were engaged in commerce?
I think it would depend. It depends, Your Honor. It depends on the circumstances and the facts of the case. And we're talking about a small county of approximately 60,000 individuals. And certainly a judge is to be mindful of their behaviors and their business practices. That's my understanding, is to be cognizant and aware, because judges are held to a higher standard as far as appearances. And in this matter, it was just the fact that this business relationship wasn't disclosed. Clearly, Judge Tomlinson indicated in his order that his wife, there was some sort of knowledge there about a business relationship. And just knowing that now and seeing and reflecting back on all of the rulings and how decisions were made and how procedural errors occurred during this time. And I'm not sure if Your Honor is aware, but the Court of Appeals did note that Judge Tomlinson violated my constitutional right to petition a court. So the Court of Appeals did affirm that. And
Objection. The Court of Appeals orders speak for themselves. Am I going to have a chance to respond to this?
Yes.
Thank you. May I do so now?
No, she can finish and then you can respond.
Um, Excuse me, Your Honor, I'm sorry.
As you're looking for stuff, I'll let you know that my staff did pull up the assignment from SCAO in this matter, and it says, under the reason for assignment, motion for disqualification. So
Is there a proof of service? And if that's listed on the register of action, is there a proof of service? Because I did not receive that.
I don't think that SCAO does a proof of service, so you'll have to contact them if that's the case.
I guess then my question would be, just for clarification, then who filed that? If it's on the register of actions, who filed that on the register?
It's not. I've got it in hand. It came to me. And
okay. I did not receive.
It's the assignment sent from State Court Administrator's Office.
That was not provided to me.
I have no idea. You'll have to talk to them.
Neither. I think that raises another question here.
You'll have to talk to them about them. It's not another issue with me. I'm not addressing what they sent or didn't send or how it got to you. You're before me, so you know that SCAO sent the matter to me. So let's just move on.
Thank you, Your Honor.
Attorney Risberg's response was methodical and devastating to Ms. Millenberg's position. She made several critical points. First, she established that the major custody decision in this case, awarding full physical and legal custody to Mr. Millenberg, was actually a stipulated order, meaning Ms. Millenberg herself agreed to it. That order was subsequently affirmed by the Michigan Court of Appeals. Second, Risberg pointed out that Ms. Millenberg had been provided with the QuickBooks files in February 2016 as part of discovery, meaning she had possessed this information for over 8 years before raising it as a basis for disqualification. Third, and perhaps most damaging, Risberg informed the court that Ms. Millenberg had actually worked at Ascend Computer Technology during the relevant time period and was responsible for keeping the company's books, making her claim that she had no knowledge of Judge Tomlinson's name in the records until July 2024 significantly less credible. Risberg also provided critical context that Judge Kirkin would not otherwise have had. There was an outstanding bench warrant for Ms. Millenberg's arrest, issued by Judge Tomlinson months earlier for her failure to disclose information pursuant to a subpoena. Risberg argued that the disqualification motion was a transparent attempt to eliminate the bench warrant by eliminating the judge who issued it. She requested not only denial of the motion, but sanctions against Ms. Millenberg for filing what she characterized as a frivolous pleading that continued to cost her client thousands of dollars in legal fees. Under MCR 2.114, say a court may impose sanctions, including reasonable attorney fees, upon a party who files a pleading that is frivolous, meaning it has no reasonable basis in law or fact and is not supported by a good faith argument for modification of existing law.
And so with the knowledge that Judge Tomlinson did, there were some concerns regarding the violation of my right to petition the court. But it's my understanding that this case is just riddled with procedural errors because my first motion to file on January 9th, 2024, I do not have any order, and to the best of my knowledge, there's no order on record granting or denying that motion. Your Honor denied a motion for reconsideration. So my records indicate that there's no order deciding the first motion to disqualify, which was January 29th, 2024. And now we move to the second one, which is July 29th, 2024. And so I guess I would incorporate everything that I've said because Judge Tomlinson himself has stated on the record at a hearing that he's unable to decide anything or do anything else until the motion to disqualify him has been decided. Likewise, on or about February 29th, 2024, the court's judicial assistant, Judge Tomlinson's judicial assistant, stated in an email, and I believe Attorney Reisberg is carbon copied on that, that was February 29th, 2024, that no determinations of any motion until after the motion to disqualify has been decided. And so here we have a case where there's lots of motions that Judge Tomlinson has made decisions on prior to any disqualification. Motion to disqualify him has been decided. And if we're just starting with opening. The lack of I believe the lack of disclosure and transparency regarding Judge Tomlinson and Mr. Mildenberg's business relationship constitutes an apparent conflict of interest.
Okay.
And a material.
You mentioned that before. I don't want to continue to reiterate the same thing that you've said before. So address what you want to address so we can get this concluded.
Okay. Well, I think there's enough here to indicate the disqualification of Judge Tomlinson, Your Honor.
Okay, thank you. Ms. Reisberg, go ahead.
Thank you. Your Honor, I think what's going on here is that Ms. Mildenberg is, obviously unhappy with Judge Tomlinson's decisions over the course of the past. I will point out to you 9 years this case has been going on. We've been post-judgment for 8 of those years. And actually, the major decision in this case to award full physical and legal custody to my client, Mr. Mildenberg, several years ago was actually a stipulated order, which then went up to the Court of Appeals, and the Court of Appeals affirmed all of those orders and determinations by the court. I did not interrupt you, Ms. Mildenberg.
Yes, don't interrupt her, Ms. Mildenberg.
Do
not interrupt.
So this is just another attempt by the defendant to get rid of Judge Tomlinson because he rules against her because her conduct warrants it. There is no relationship between Mr. Mildenberg and Mr. Tomlinson outside of the courtroom. In her own motion, as this court so astutely pointed out immediately, and I've got it circled on mine too, number 2, on the July 29th motion to disqualify, Ms. Mildenberg indicates that in 2016, my client provided her, through counsel, I'm sure, all of his business records. And she's had this information. She worked there. She's also not told the court that she kept the books for Mr. Mildenberg during the times that she's concerned about Mr. Tomlinson's wife allegedly bringing an iPad for some staff person to say, we can't help you with it. She worked at Ascend Technology during that time. She had access to the books. She was disclosed all this stuff in discovery. She had 9 years to look at it. It's been 8 years since she has had this information and had a chance to review all of this. And there was nothing to disclose. Judge Tomlinson, in his ruling on this issue, says, I think my wife might have taken an iPad that didn't charge there. There's no money that changes hands. Again, the court's already astutely pointed out that this would literally prevent any officer of the court from doing ordinary business in the community. You'd have to think back, 2 years ago, before I took this case on, did I take an iPad or did my wife take an iPad to a local business, and is that person a party to a case in front of me? This court knows that this makes no sense whatsoever. It's a desperate grab for Ms. Mildenberg to try to avoid the current bench warrant that's out for her arrest that was issued by Judge Tomlinson several months ago for Ms. Mildenberg's failure to disclose information pursuant to subpoena for several years. That's outstanding right now. She should probably be picked up on that bench warrant, if you ask me. And she's trying to get rid of the bench warrant by getting rid of Judge Tomlinson. The previous ruling on this issue, the initial disqualification that was filed in January, was decided. It went in front of this court pursuant to SCAO reassignment, and this court decided that there was no need for disqualification. Deciding a motion for reconsideration on the same issue renders the same result. We're here again today on a new motion with these new facts. I don't even remember what the past basis for disqualification was. But today, the issue is that Judge Tomlinson's name appears in QuickBooks that Ms. Mildenberg had access to several years ago. There's no conflict, Your Honor. There never has been. There isn't one. She's trying to wrestle out from underneath a valid bench warrant. And frankly, she should be sanctioned for this. She admits she had the information. She knew about it since 2016. She had that information at her fingertips. We're here again. I know this court has nothing to do with the other pleadings, but it has been 9 years of this. And we show up and Ms. Mildenberg acts like she hasn't gotten notice. She wants to hang her hat on procedural, glitches or misunderstandings and try to act like her due process has been denied. She's had every opportunity to be heard fairly by Judge Tomlinson, who, in my opinion, has afforded Ms. Mildenberg an extreme amount of deference as an unrepresented person and an extreme amount of personal grace. So the fact that she is now moving to disqualify him should again be sanctioned by this court. It continues to cost my client thousands of dollars for me to prepare and appear over and over and over again on these hearings, especially when, and again, you're not present on the St. Joseph County hearings, almost every time there's a request for an adjournment from Ms. Mildenberg with a vague flu-like, COVID-like symptoms. And if she acts like she didn't have notice of this, we had very, very specific phone calls and emails with Ms. Woodward trying to settle on a date for this, which Ms. Mildenberg said she was unavailable till December, and we were able to finally find this date. So I would ask that the court deny the motion for reconsideration and the underlying motion for disqualification, which is inherent and embedded within that same request, and sanction Ms. Mildenberg for the frivolous pleading.
Anything else?
I can have my client testify if
No,
this
I don't
court
take
is
testimony at these hearings. There's no,
perfect.
under 2.119 parens F, there's no basis for taking testimony. And in fact, again, there's no oral argument unless the court allows it. I've allowed it in this matter, but that's all. Ms. Mildenberg, is there any response that you have to Ms. Reisberg?
Yes, thank you, Your Honor. I just want to touch base on that Court of Appeals opinion because Ms. Reisberg indicated about custody. The Court of Appeals was
Ms. Mildenberg, I'm not concerned. I'm not addressing anything that the Court of Appeals has done. If you want to have anything with regard to that, take it up to the Court of Appeals.
No, I understand, Your Honor. Thank you. I was just addressing Ms. Attorney Reisberg's comment regarding the Court of Appeals and how I was going to say that the comment was misleading.
Again, I don't care about that. I'm not deciding that. So I'm not going to get off on that tangent. So address anything about the motion that we're here on today, and we'll address that.
Attorney Reisberg indicated that I was responsible or did the QuickBooks or the accounting for us on computer technology. And Your Honor, I will acknowledge that is true. However, I was not responsible or did not have knowledge of every transaction that went through the business. Certainly, I was the primary caretaker of our children during the marriage. And so a lot of time, most always, I was the one that stayed home and took care of our children. So I was not at the office on those days. I obviously wasn't in the office when I was on maternity leave for the births of our children. And there were days and times where I was attending things at our children's school. So I wasn't around for all of the transactions, and nor would I see any of them because there are numerous ones. And many of the transactions didn't always involve me knowing the details of each and every customer that walked through that store. I was responsible for other things, more like monthly and quarterlies and most of the accounting, but the day-to-day and seeing everyone walk through that office was not something that I witnessed all the time. So I would not have knowledge of that. And I reported this as soon as I discovered it. You know, just because I had these USBs back in 2016, never did I think or anticipate that I would discover that Judge Tomlinson's name would be in our books. I wouldn't, and I would have expected that if there were any potential for a conflict of interest, and that if Judge Tomlinson's name appeared or his wife had any sort of business relationship and with Ascend Computer Technology, I have the right to expect that the judge would disclose that. And certainly, I would like to believe that if a judge takes a case and sees, oh, Ascend Computer, did we do any business there? You know, or ask himself. Clearly, his name was in the books there from at least 2013. That's not to say that his name wasn't in there earlier. And that's all I had. The earliest I had was 2013. I think Mr. Mildenberg has been in business since 1999, to the best of my recollection. So I think it's a little bit. I think that's a bit unrealistic for it to be expected of me to know every single customer that came through that business when I was not there for plausible or, you know, for good reasons. And again, I was astonished. I was not expecting to find Judge Tomlinson's name in Mr. Mildenberg's business records. And when I did, I reported it as soon as I noted it. So I think it's unreasonable for anyone to expect me to have known this, because I didn't. As soon as I discovered it, I reported it. So,
May I respond extremely
Yep.
briefly, Your Honor?
Go ahead, briefly.
Just as Ms. Mildenberg argues that she would have no way of possibly knowing every single customer who walked through the door, neither does Mr. Mildenberg. That's like saying, hey, Ms. Mildenberg, who was, likewise with Judge Tomlinson, he can't be expected to remember every single service provider he has used 10 plus years ago. That would be like saying, Ms. Mildenberg, you hired a plumber when you were, living with 10 years ago. What was the name of that plumbing company? Or you ate at a restaurant in March of 2015 in April. What was the name of the restaurant and what did you order? This is nonsense. The court knows that this is nonsense, and there is no basis for disqualification based on these facts.
Thank you. Well, thank you. I've heard it. I've obviously read the motion as well as the brief in support. Obviously, from the first occasion when the court was assigned, and now this time with the most recent, what the court will do is I'll take it under advisement. I will render a written opinion, and I should have that out by the end of the week, and then you'll receive that. So you're free to go today. Have a wonderful day.
Thank you.
There's no way he's granting this motion. I'll keep an eye out, of course, to see if they stream a ruling, but there's no way.
Judge Kirkin took the motion under advisement, stating he would render a written opinion by the end of the week. While the ruling was not issued on the record during this hearing, the trajectory of the proceeding made the likely outcome clear. There was no factual or legal basis for disqualifying Judge Tomlinson based on the allegation that his wife once brought a non-functioning iPad to a computer repair shop a decade ago, received no service, and paid nothing. This case is a textbook illustration of a phenomenon that family courts across the country encounter with troubling frequency: the weaponization of procedural motions by a party who is unhappy with the court's rulings. Ms. Muhlenberg's case had been pending for 9 years. The custody determination she was challenging was one she herself had agreed to through stipulation. The Court of Appeals had affirmed the trial court's orders, and rather than complying with the court's directives, including the subpoena that led to the bench warrant, Ms. Muhlenberg chose to pursue a strategy of attempting to remove the judge through successive disqualification motions, each based on increasingly tenuous grounds. The standard for judicial disqualification in Michigan, and in every American jurisdiction, requires more than a party's subjective belief that the judge is biased. Under MCR 2.003 C.1, disqualification requires objective evidence that would cause a reasonable, informed person to question the judge's impartiality. A single, decade-old, non-compensated interaction between a judge's spouse and a party's business, an interaction that amounted to being told an iPad could not be repaired, does not meet that standard by any reasonable measure. As both Judge Kirkin and Attorney Risberg observed, adopting Ms. Meilenberg's interpretation would mean that no judge in any small or mid-sized community could ever preside over a case involving a local business owner if any member of the judge's family had ever patronized that business. The standard would be unworkable, absurd, and would effectively disqualify every judge from every case in communities where people regularly interact with the same businesses, schools, churches, and service providers. What makes this case particularly instructive is the contrast between Ms. Meilenberg's procedural maneuvering and her failure to comply with the substantive obligations the court had imposed on her. She filed multiple motions for disqualification. She sought adjournments. She claimed not to have received notices. She argued about the procedural irregularities of the SCAO assignment, but she did not comply with the subpoena. She did not provide the information the court ordered her to produce. And she did not accept the custody arrangement she herself had stipulated 2 years earlier. At some point, the legal system's patience is not infinite, and when a party uses the procedural machinery of the court not to seek justice but to delay, obstruct, and avoid accountability, the court has both the authority and the obligation to put a stop to it. Whether through denial of frivolous motions, imposition of sanctions, or enforcement of outstanding warrants, the court must protect the integrity of its processes and the interests of the parties, including the children, who are affected by endless, meritless litigation. Let us know if there is a case or legal topic you'd like us to cover next.